everybody. I can see that people are just starting to join us, so I'll just give everybody a couple of minutes to get in and join us. Welcome. It's good to see so many of you attending again. So we'll just give a couple of moments while we're waiting for the rest of our participants to join. But hopefully you should be with us in a couple of moments. Okay. Well, we will start with some introductions. I can still see one or two are still joining, but good morning. I'm Ruth Rule-Mullen, and I head up the employment law side of things in the education team. And I'm really pleased to be joined this morning by several of my esteemed colleagues. So I'm joined by Emma Swan, who works in our education team, advising on lots of different things, and she's got some exciting information to talk to you about this morning about parental complaints. I'm also joined by Jack Tasker this morning, who works in our commercial litigation team and is someone who we will need if we're getting into any court claims and debt recovery and those sorts of things. I'm also joined by Coral Putrell this morning, who works alongside Emma Swan in our education side of things, and Sam Gorrell, who works in our property team and is used to dealing with all things education as well. We are hoping to be joined by our regular attendee, Gemma Duxbury, this morning, but unfortunately we've got some technical issues. So hopefully Gemma might be able to still join us, but we will get underway. We decided this morning we've got some questions that have come through, but we also wanted to talk to you about some questions that we've been being asked as well, just to see if those will help you. So we're going to take some of the questions that have come through, and then we will move on to give you some of our sort of topical questions that we've been asked outside of the session today as well. And as always, please do go through and pop any questions that you have into the Q&A, and we'll hopefully be able to answer them live with our experts this morning. So good morning, panel. Good to see you all.
Morning everyone. Good to be here.
Morning, Emma.
Morning, everyone.
Hi,
Morning.
Sam. Good to see you. Hi, Jack. And we've got Coral as well, who's gone quiet on me, but I'm sure he's going to say hello as well. Hi, Coral. Good morning. So then let us get underway. And as I say, any questions or any comments or anything that you want to kind of put to the panel or put out to our colleagues who are attending, please feel free to pop that in the chat, and we'll pick that up as we go. So I'm going to start with a question that we've had about the management of notice periods. And the question has been around whether a week's notice period would still apply in the example of a new teacher who is an early careers teacher, has poor conduct or is always late, and has been unprofessional or breached policy guidelines. So the question is, can we still apply the 1 week notice that we would have in our contracts to that individual? And the answer is going to be, it will obviously depend what is said in their particular contract, first of all. Assuming that is in their contract, that notice period technically should apply. The difficulty always is with early careers teachers that the purpose of that induction period is, of course, to monitor and assess through that process. So it wouldn't necessarily just be a case of saying, well, there's a 1 week notice, off they go. There will be a process to follow first. And in accordance with the statutory guidance on this, you would have to go through that process, monitoring informing them of the issues that are occurring within that, because whilst you think that would be obvious, obviously you have to address it. And there could be reasons why that person, for example, is being late. There could be something like they have caring responsibilities, and you might need to take that into account. And until you have those conversations, sometimes we don't know what's going on. Also, with early careers teachers, we can extend the induction period in certain circumstances. So we do need to understand the reasons why that thing is happening. If it transpires, of course, that they are simply being late regularly, then and there's no real reason behind it that could lead to a discrimination claim, for example, then you may be able to go through that process, and ultimately the relevant notice periods would apply. There are requirements to report back to the statutory body in respect of it, and also in terms of dealing with that process, we need to remember as well that that person will then be prevented from teaching in a school unless they can secure that induction process somewhere else. So it is quite a big deal, I suppose, to dismiss somebody in those circumstances. So it does require some considered thought. But ultimately, once you've gone through those processes, the notice period would apply. So, bit long-winded answer, but essentially the crux of that is there are processes to follow, but ultimately it would be the notice period kicks in once you've gone through all of those processes. So it would be important to start those processes, in early course once those things are starting to show or go wrong. And of course, the purpose of the induction process is to make sure that person's going to be fit for teaching going forward. So hopefully that has answered that question. I'm going to come on to a question that Sam has been asked, and matters that he's been dealing with. And this relates back a little bit to our sort of theme today around crisis management and all the things that potentially can go wrong. So the question we've just had was a good one to start with, because it can be a bit of a crisis when things are going wrong with our staff. But Sam's questions that he's asked quite a lot are around things like dish repairs in schools and when those become sort of to that crisis point that they've got to be managed, but also how to avoid getting to a crisis point. Hopefully that's a good enough introduction, Sam, and you can talk about the questions that you've been asked.
Yeah, thanks, Ruth. Good morning, everybody. As Ruth said, we often receive inquiries from schools in relation to damage to buildings. Can often be in response to actual damage that's been caused to a school site, or as part of queries that are raised around repairing obligations at the time when a school is taking ownership of new land and buildings as part of an acquisition, most notably at a time when schools convert to either become academy trusts or join existing academy trusts. The thing we always kind of come back to in the event of damage to any property, be it a one-off event such as adverse weather conditions or just long-term general wear and tear, is to look at the documents that grant you your interest in land to see whose responsibility it is to repair the damage that's been caused. So for those of you who are occupying your school site under the DfE's 125-year model lease, due to the nature and the length of the term in particular, the repair obligations will invariably fall on the Academy Trust. In particular, the Trust will be responsible for keeping all buildings, structures, landscaping and other erections clean and tidy, and making good any damage caused to the property and any deterioration in the condition of the property that will arise from the date of the lease. It's also important to check the exact wording of the lease, as there may be other requirements contained within, such as the need to notify the landlord if any structural damage occurs to the property. But what if there are other forms of occupancy agreement that you're occupying the land under? What if it's not just the standard 125-year lease? Some of you may be occupying your school site under a church supplemental agreement. And the terms of that can depend or can vary depending on whose responsibility it is to insure the land. But either way, the repair obligations in respect to the land itself will again fall on the trust. Similar to the DFE model lease, there'll be a need to make good the land and repair any damage that's caused, and also repair any deterioration in the condition of the land. In reality, it's going to be the trustees that will be called upon to give effect to this, and the supplemental agreement does require trustees to facilitate any maintenance, upkeep or replacement of buildings and facilities on the land. However, that's always provided that the trust will meet the cost of the repairs in recognition of the funding that the Secretary of State provides for the running costs of the Academy. We often find that schools will occupy additional land, often under a licence. We've come across woodland schools that are used and made available through the local authority under a licence. Again, the terms of the licence can vary depending on the nature of the land, but in terms of repair covenants, they're usually much less onerous than they are on a tenant under a lease. So there'll usually be an obligation to look after the property and keep it clean, tidy and clear of rubbish, but there's not usually an obligation to repair, given that the nature of a licence is the grant of a permission to use the property. So this means that the property will remain in the ownership and control of the licensor, who will be responsible for keeping it in repair, the licensor being the owner of the property. That said, the licensee will undoubtedly have an obligation not to cause damage. So if damage has been caused by the school, then it can find itself liable for the cost of the repair. But it would usually be for the owner to carry out the remedial works and then look to recover the costs from the school. And what if you own the freehold? Well, it is rare to find that a school or an academy trust will own the freehold land on which it's situated. But if it is the case, then responsibility for repairing the land and buildings will lie with the school or the trust as the freehold owner. That tends to be the case, except in exceptional circumstances where liability may rest with another party. That can usually be in relation to boundaries, boundary walls, where it may be the neighbouring property owner has the obligation to keep that boundary in repair, or it may be a shared boundary, in which case both parties will be responsible. If you're unsure, it's always best to check your documents, your deeds, and we can give advice around that. If you've got any questions as to who's responsible for repairing any particular part of your school site, by all means just get in touch and we can help with that. We're aware that repair obligations will normally come hand in hand with insurance, and that most schools will insure their sites through risk protection arrangements, which will protect against a whole variety of risks. If damage has been caused by an insured risk, then provided you've not contributed to the damage in any way through acts or omissions on the part of your employees, agents or other authorised persons, then obviously you'll be able to recover the costs of reinstating the property through insurance. It's important to note that under the DFE model lease, there is an exemption which allows you to hold off from carrying out any repairs if you're actively pursuing an insurance claim. You'll obviously need to make sure, though, that the property is kept safe in the meantime, in line with health and safety duties. And if there's any concerns about what that entails under the legislation, then by all means, pick up the phone and give us a call. We're happy to kind of have a discussion around that. Often it might not be you that causes the damage, but third parties, neighbouring landowners, or anybody that's using your school site as well. If in the event that there is damage caused by a third party, obviously you'll want to look to them to remedy the situation. Be mindful of safeguarding requirements that you have in order to ensure that pupils are safe, which may not mean that it's possible to wait for liability issues to be resolved or for those third parties to carry out the works. So it's likely you're going to have to do the works yourselves and then recover the costs once it's been established who's responsible, particularly where that helps to demonstrate that you're mitigating your losses as well. If you are ever considering bringing action against a third party for damage to property, then again, pick up the phone. We recommend speak to legal advice, seek legal advice in the first instance, because that can inform how you go about obviously carrying out the works and putting other people on notice of them potentially being liable for those costs. Why is it important? Well, obviously you'll want to know what your repair obligations are in respect of your school site and all parts of that site. There's almost certainly going to be a desire to act quickly to repair any damage caused in order to ensure that you're managing your health and safety duties. But also when you're occupying the school site under a lease, there's a risk that if you don't comply with your repair obligations, then the landlord may take it upon themselves to carry out the works in default. The DFE model lease, again, requires schools to allow landlords to access to the property to examine the state of the repair and condition of the property. So at any given point, they can call upon you to carry out an inspection. They can do this with or without equipment upon reasonable prior notice, and that's always subjective, and at reasonable intervals during the term. And if they do find that the property is not in the condition that it ought to be in, they can give you a repair notice, and that sets out in writing any of the breaches of the lease relating to the condition of the property. If you receive a repair notice, then the obligation on you is to use all reasonable endeavours to obtain as soon as possible any necessary consents to carry out the works that are needed to put the property back in repair. And then you'd be expected to do the works within a period of 56 days after getting that repair notice, which isn't a lot of time in the grand scheme of things, particularly if you find yourself on the back foot, having been told of the need to carry out repairs by the local authority following any inspection. You've got to obviously ensure that you carry out the works diligently thereafter, which again can sometimes be a challenge. And whilst there are provisions in place under the lease that allow for those time periods effectively to be extended where funds aren't available, or if there's a need to apply to the Secretary of State for further funding under the funding agreement, there'll still be an expectation that those works are carried out as quickly as possible. So knowing what your repair obligations are in respect of the school site is going to give you the opportunity to get ahead of the curve in that regard, in the event that there is any damage that occurs. As I said, the starting point is always to check your documents, and one thing that we are able to do here is carry out reviews of documents and report to you on various issues concerning those. So if you did have, as I said, any questions, or you are unsure as to exactly where your responsibility lies, then by all means pick up the phone, because the last thing obviously that we would want for you to find is that the local authority are threatening to carry out works to the school and charging you the cost of doing that, because ultimately that can end up being a lot more expensive than it would be if you were to do the works yourselves.
Brilliant. Thanks, Sam. It's true to say as well, isn't it, Sam, that we do get some weird and wonderful things happening around schools. I think we've seen
trees falling over
onto other people's properties. I mean, we can't, to some degree, we can't always prevent those sorts of things, but it's just really being alive to what support and help that you need and where you can get it. So we would say that if there's any weird and wonderful things around neighbouring properties, problems with your own properties, that's when to give you a call, isn't it, Sam?
Yeah, if there's any incidents and you're unsure as to where the responsibility lies, or if you're generally just wanting to, I say, carry out a document review so that your processes are up to date and you know exactly what to do in the event of a crisis. This is all about being able to react quickly. Then we can obviously assist with preparing any reports and advices where needed. Brilliant.
Thanks, Sam. I can see one of our attendees looks like they've got a hand up. If you've got a question, could you please pop it just on the Q&A for me, and I'll be able to pick that up for you, because on this Zoom function, I'm not in a position to kind of let you in and let you speak. But if you could drop me a quick note on the Q&A, I will pick that up for you. But thanks, Sam. That's really helpful. So keeping with that theme of crisis management, I'm now going to move on to my colleagues Emma and I think Coral as well, to talk about parental complaints. That is something that we're seeing happen quite a bit at the moment, and we seem to be getting a lot of queries around that. And I know people want to know what to do. So Emma, unfortunately, we can't see Emma's face this morning, but she is here and willing. So Emma, I'm going to hand over to you.
Absolutely. Thank you, Ruth, and good morning, everyone. Apologies that you can't see me. I promise I'm not having a bad hair day. I think it's just a technical issue with the camera. So just going forward with what we're going to cover today, as Ruth has mentioned, we're going to be talking about managing parental complaints. I think it would be fair to say that over the last couple of years, the volume and complexity of complaints that we've certainly seen schools receive has increased significantly. So as a starting point, what I would say that your complaints policy is basically your first line of defense. So that's the most important thing that you can make sure is absolutely robust to best protect your school. So what I would usually recommend is that you have two complaints policies in place. So one would essentially be for parents and another for members of the public. And why we say that is the policy that you would have for parents needs to comply with a lot of requirements that are set out by the DfE, and they're set out in the Education Independent School regulations. So essentially, for parental complaints, you need to have 3 stages. But for members of the public, that isn't at all necessary. The policy can be far more streamlined. So this is very useful if, for example, you're dealing with complaints, say, from former parents, which can often be, that can be a protracted complaint that's ongoing, even when they've left the school, and also, say, perhaps for disgruntled neighbours. It's far better if you can have a policy that's less burdensome for your school, so you can resolve matters more quickly. Now, in terms of the sort of things that we see in complaints policies that I would say would be worth flagging up, sometimes we see policies that don't impose a timescale for parents to raise complaints, or it has, say, an unnecessarily long time frame. Now, I would always recommend that parents are allowed, say, around 3 months to raise a complaint, following which it will be deemed out of time, unless perhaps there are exceptional circumstances, say, serious ill health. The timescales need to be clearly included for parents to progress through each stage of the policy. And this is something that we quite often see at various stages is missing or isn't at all clearly set out. Now, if a parent fails to comply with those timeframes, then that means that your school can effectively deem the complaint to be out of time. Your policy also needs to very clearly set out what can and can't be dealt with under the policy. So, for example, complaints about omissions and exclusions should be managed under separate statutory procedures. However, there are certain nuances. So, for example, if it's a complaint about other sanctions that may be imposed on a child, say, for example, isolation, then that may be dealt with under the complaints policy. Now, when we're looking at the various stages of a complaints policy, how it is set out needs to be dependent on the type of school. So, for example, for maintained schools have more freedom to choose how many stages their complaints procedure will include. Now, it's usually recommended that complaints will be dealt with in 2 stages, and the second stage would effectively be the appeal stage, where complaints can be heard by members of the governing body. What it's really important to be mindful of, and we do know that schools can get into a bit of a muddle here, the appeal stage should not only consider how the complaint was handled procedurally, it must also consider the substance of the complaint itself, and that's really important. So you need to be looking at the merits and the substance of the complaint and not just how it was managed procedurally up until that point. Now, for academies, as I touched on, there's the Education Independent School Regulations that are in place. These regulations apply both for academies and independent fee-paying schools. Now, these schools are required to ensure that their complaints procedure complies with the regulations, so it must consist of at least 3 stages. That's essentially the informal stage. The complaint there may go to, say, a class teacher. There's then the formal stage. It may potentially go to the head teacher, or if it's about head teacher, perhaps chair of governors. And then there is the independent panel hearing. Now, the appeal stage is where we most frequently see schools getting themselves into a bit of a pickle. So if we're looking firstly at maintained schools, what I would say is that for maintained school, if you're progressing to the appeal stage, a few points to think about. Obviously, you need to ensure that any governors involved in the appeal don't have prior knowledge of the complaint, don't have any conflict of interest. If your governors can't act impartially, then you may need to source governors, say, externally from another school. The complaints committee for a maintained school can decide whether to deal with the complaint by a meeting or through written representations. If your school is an academy, however, then you need to hold a hearing where each party will be given the opportunity to give statements. Then the panel, the parents, school representatives can also ask questions. Now, for academies, the other points to flag up are that the panel should consist of at least 3 members who have had no prior connection with the complaint. At least one of these individuals must be an independent panel member to ensure that there's an external source of scrutiny. The independent panel member should not be a member, a trustee, or an employee of the school. If your school is within a multi-academy trust, it is the case, however, that a governor from a local governing body at a different school within the MAT who has no conflict can actually be an independent panel member. So that's worth thinking about. Now, you may find in some cases, particularly where things become very contentious with the parents can request a fully independent panel if they believe it's likely to be biased. That's something that you would need to consider as a school. You don't absolutely have to agree. However, in those circumstances, if challenges are being made by the parents, it is something sometimes that it's sensible to consider that at that point. We have seen, certainly historically, some complaints panels have made the mistake in trying to be helpful of allowing a parent to submit new information that may relate perhaps to a new complaint, or it could just be information that is not really related to the complaint itself. Now, I would say that's something to carefully consider. Otherwise, you're unable to look at how that aspect was managed previously. So it's something that sometimes independent appeal panels can just get into a little bit of a muddle about. So I just flag that up to make sure you don't allow any further new complaints to come in at that stage at all. If there was a brand new complaint from that parent, then they would have to go through the process again and effectively start from the beginning of the complaints procedure. So, Coral, I wonder if you could just perhaps talk about some of the complaints that we see arising and perhaps provide some tips on responding to a complaint.
Of course, thanks, Emma. Good morning, everyone. So following a period of crisis, and for example, we saw this during and following COVID, schools might receive an increase in complaints. Similarly, if there's been a safeguarding issue at a school, it's likely that parents might contact the school to raise some concerns. Even during a crisis, continue to follow your policy. What we see is that it can be easy to simply do as parents request to avoid inflaming a situation and to ultimately try to be helpful to the parents. But the best protection for your school is to follow your policy and the department's guidance. So, for example, where matters which are likely to require a child protection investigation are out of scope of a complaints policy and should be handled under the school's child protection and safeguarding policy and in accordance with relevant statutory guidance. But there might be instances where a complaint considers themes which might be out of scope, but the crux of the complaint itself falls within the scope of your policy. So we're thinking here, for example, parents may have concerns in respect of language used by a member of staff when liaising with them in respect of safeguarding concerns. That complaint can be managed pursuant to complaints policy, but make sure to only investigate the scope of a complaint, not the incident itself. When responding to a complaint, one of the reasons that we see parents more commonly exhausting the entirety of a school's complaints procedure is because the response from the school was not full and clear, or it comes across as too defensive, and apologies at an early stage can go a long way to nipping issues in the bud. So your response should clarify the process which has already been followed and the current stage of the complaint process, and that's really helpful for future record keeping. It should fully detail the investigation which has been carried out and the decision reached in respect of each element of the complaint. And when we're talking about each element of the complaint, for example, if a parent raised a complaint following their child being sanctioned for wearing a nose piercing, and they also highlight that the uniform policy is unclear and the sanction was not in line with the behaviour policy, your response should separately set out the investigations conducted and the outcome in respect of each element of that complaint. So it might be that some parts of a complaint are upheld and others are not, but just make sure to really clearly distinguish between them. The response should also set out the steps for the parent to progress their complaint to the next stage. So, for example, following the appeal stage, you need to clarify that the next stage would be to raise a complaint to the department. The department can't overturn the decision about a complaint. It will instead check to make sure that you have followed a process which is in line with their requirements. And action taken by the department does typically involve recommending improvements to the school's policies. It's always best to allow a parent to pursue a complaint where they are entitled to do so. Schools aren't expected to get everything perfect, and helpful lessons can often be taken from complaints, and you're far more likely to face scrutiny if you don't follow your policy or don't allow a parent to exhaust the policy where they have complied with the expectations placed on them. We're also increasingly having conversations with schools in respect of the impact of AI in education and how it can be implemented, as well as considering how schools can benefit from AI. Over the last few years, I'd say, we've seen an increase in complaints which are clearly being generated by parents using AI. So parents are putting information into an AI tool, which then produces lengthy, poorly phrased letters with incorrect references to statute and guidance. And that takes time to go through to even understand what the issue is and what the parent is seeking. So again, it can be easy to sort of slip up and just do as a parent's wanting, but make sure that you still manage these complaints in line with your complaints policy. It might be necessary to raise clarifying questions if a complaint is particularly challenging to understand because of the use of AI. As well as managing complaints which are made more challenging because of AI, we are also seeing parents acting unreasonably when pursuing complaints. For example, we get queries and have supported clients where parents have explicitly stated that they are attempting to cause nuisance to the school. And the first port of call, as always, is make sure that your policy is drafted to protect your school in the event of unreasonable complaints. So in some cases, parents don't accept the outcome of their complaint, even once they've exhausted the entirety of the policy. So we've seen them place pressure on schools to revisit their complaint or attempt to rephrase their complaint slightly and have it dealt with again, although the crux of the complaint will have already been dealt with. If this happens and a parent attempts to reopen the same issue, inform them that the procedure has been completed and that the matter is closed, and make it explicitly clear that the school will not respond on the matter any further. If the parent subsequently contacts you to raise the same issue, the correspondence can be viewed as serial or persistent, and you can choose not to respond. We also get queries and have advised schools where they don't see the value in progressing to the appeal stage because they consider that the outcome will be no different. Unfortunately, that's not a valid reason to prevent the parent from exhausting all stages of the policy, and it's key that you don't mark a complaint as serial before the parent has completed all stages of your procedure. Also, you should not refuse to accept further correspondence or complaints from the parent more generally. So the application of a serial or persistent marking should be against the complaint itself and not the parent. We also see and support schools that are receiving complaints that are vexatious. So these are complaints which are, for example, obsessive, persistent, harassing, raising large numbers of detailed but ultimately unimportant questions that the parents want fully answering, sometimes immediately. Parents seeking to replace or make unjustified complaints about staff who are trying to deal with their complaint. And we also see parents introducing trivial or irrelevant information and expecting it to be taken into account and commented on. We also support schools quite a lot where parents are using social media as a tool to leverage schools. So we recommend that your policy explicitly states that where a parent publishes or threatens to publish information, including on social media, websites, or in newspapers, the complaint will be considered unreasonable. If a parent does go ahead and publish information on social media, we can support in reviewing the post and, where necessary, acting to have it removed. So do get in touch if that's the case. Whilst there are circumstances where you can legitimately stop responding, it's a decision that shouldn't be taken lightly, and you need to be able to satisfy yourself that you've taken every reasonable step to address the parent's concerns. The parent has been given a clear statement of your position and their options, and the parent contacts you repeatedly, making substantially the same points. As tempting as it may be, you can't stop responding just because the parent is difficult to deal with or asks complex questions. Now, the case to stop responding is stronger if the parent's communications are abusive or aggressive, or they make insulting personal comments about or threats towards staff. Of course, swearing at members of staff, threatening staff with violence, or making disparaging remarks about a member of staff's appearance or intellect could be considered abusive or aggressive. However, questioning whether a member of staff is performing their role effectively is generally not unreasonable, so you need to take that on board when you're looking at managing your complaints. There are strategies to manage parents, which we have seen be quite helpful to some of our clients. If the parent's behaviour is causing a significant level of disruption, you can implement a tailored communication plan, and this is a strategy which we have seen success with. So, for example, you can restrict the parent to a single point of contact at the school, limit the number of times that the parent can make contact, or suggest that the parent asks a third party to act on their behalf. And those tools can just help to de-escalate the situation a little. If a parent's behaviour is a cause for concern, for example, if they're displaying aggressive behaviour, the head teacher can ask them to leave the school premises. In more serious cases, the parent can ultimately be barred from entering the school premises to prevent any future risk. There are certain requirements to be followed when seeking to bar an individual from the premises. So, for example, the individual needs to be given an opportunity to formally express their views on the decision to bar them, and the head teacher's decision to bar should then be reviewed by the governors. If the decision to bar is confirmed, the individual should be notified in writing, confirming how long the bar will be in place and when the decision will be reviewed. And we'd always say around 6 weeks is a good review period. So just some top tips to round up when you're responding to a complaint, particularly in a moment of crisis. Policy is key. Make sure your policy is robust, sets out timescales for each stage and separates parents from members of the public. Make sure your responses are full and detailed to allow the parent to understand what's been done to investigate the complaint and why a particular outcome has been reached. Have a written policy for managing serial and unreasonable complaints. And remember that parents may have good reason to be frustrated, and apology can sometimes go a long way in seeking early resolution and nipping it in the bud.
Thanks, Coral. I think it is a real area of concern. I'm sure a lot of our attendees are seeing these sorts of things. And if you're not, unfortunately, with the introduction of AI, we think you will be. So it's a really good point to, put that over, and hopefully our attendees are seeing that. Obviously, attendees, please do pop anything in the chat. Let us know. Are you seeing more complaints? Are you seeing the use of AI? It'd be really helpful to know kind of if you're seeing those sorts of things too, because that's the sorts of things a lot of our clients are seeing at the moment. But hopefully that's giving you some really good pointers in the right direction. The next question is one that we've had in, which is to talk about governors' meetings. Now, unfortunately, our colleague Gemma hasn't been able to get here this morning, and she's our resident GDPR and data protection expert. But I'm going to have a go at.
I have arrived.
She's here. Look at that. Perfect timing, Gemma. Well done.
Horrendous.
Gemma is here and has just saved you from Ruth talking about data protection.
No, I don't know what the question is though. So what's the question?
That's okay. I can help you with the question.
Perfect.
It's around governors' meetings, Gemma, and creating the minutes of governors' meetings and how people can record those without sort of breaching confidentiality, and how to protect sort of, their information and any confidential matters, and anything where they are not wanting to sort of share that openly.
Okie doke, yeah. So there are ways of doing that. I mean, the first thing I would always advise, and I know this sounds like a bit of a cop-out, but it really does make a difference in my personal opinion, is that you get a good clerk. That is a really, really important thing for not just governors' meetings, but trustees. It means that there's somebody there with specialist knowledge that can help you with these sorts of concerns and queries, and that can steer you through these types of situations. I do understand sometimes people might not want to actually do that, or they might want to clerk it themselves, which again is okay, but usually we would advise that you get somebody with that expertise. The second option is that you can divide out and you can agree in the meeting what information needs to be kept confidential and what doesn't. So you can do a version of publishable minutes and a version of confidential minutes. And so that's the way to protect the information. You do have to be careful, though, about what you're deciding not to disclose, because you can't just do it because you don't want people to know about it. Sometimes, that's obviously going to be important because they're going to want to see that you're actually talking about those things. It might be a very relevant subject, but there are ways that you can actually keep confidential certain parts of the minutes. A lot of the time as well, people will say, not for minuting, please, in the middle of a meeting. I think Ruth and I have done that a few times, and we've certainly seen other people do it as well. If you want to say something perhaps a bit more off the record, you can actually say, please don't minute this, or can we treat this as a separate conversation? So there are ways of doing it, but usually the best way to do it is to go through a meeting, and then at the end of the meeting, usually the clerk or whoever is going to be taking the minutes will say, do we consider that any of these minutes need to be kept confidential, or whether or not we need to separate out any information? And that's when you would make the decision. You can say it while you're talking about it as well, obviously, but usually that's the way that it goes. I don't know if you wanted to add anything to that, Ruth.
No, that was everything I was going to say, honestly. No, great. Gemma, we've just been talking a little bit this morning about crisis management. So I just wanted to sort of give you a minute or two to just sort of mention the crisis points that you see in your team where schools might need something fairly urgently, or something happens and they don't know they might need you urgently. Did you want to just touch on that for 1 or 2 minutes before we move to the next person? Is that okay?
Yeah, of course. Yeah, no problem at all. So there are lots of different situations where crisis management situations arise. And a lot of the time, unfortunately, with clients, what happens is clients will try and deal with things themselves without necessarily having the knowledge and expertise about the legal element of it. And then they can end up getting themselves in a bit of a pickle. And particularly recently, I've found this with subject access requests from disgruntled parents or disgruntled employees or members of staff that are not happy, so they've submitted a subject access request. A lot of the time people will try and be supportive and provide that information, but a lot of the time what they'll actually do is they'll provide information that they shouldn't do, or they don't redact it correctly, and they can end up getting themselves in a little bit of a mess. We've had quite a few clients recently that have tried to do that. They've tried to deal with a DSAR themselves, ended up that the person has come back and said, you've not fulfilled your obligations. You've not provided all of the information correctly. You've not provided this, and this. They've then come to us and we've said, right, give us all of the information. We'll redact it and we'll sort it out for you and we'll send it back. And then a lot of the time you will get further complaints from the requester because they will say, well, you didn't include that this time and you've blocked this out that time and you've done that. And that's because we legally can identify what you should and you shouldn't provide. And a lot of the time you will mistakenly just provide that without doing anything with it. And it ends up that we then have to say, no, legally, in the eyes of the law, this is all you are actually entitled to. So that's one area that we've had a lot of issues with. We also have a lot of issues with other data protection concerns and also with contracts and things like that. COVID obviously was a massive one with crisis management where people needed to act sharpish with their suppliers, looking at their contracts, policies, because they weren't prepared and ready to deal with the situations, particularly with coming back from COVID. I think that was a massive thing, wasn't it? Because of the requirements and everything that went with that. So even though it probably sounds like, oh, Gemma does data protection and she does all the other public sector element side of things, crisis management does come up quite a lot. And I would always say, and particularly this is what I love about Forbes, because a lot of people know my background and I actually worked in-house in a local authority for 10 years. What I love about Forbes is we're not going to start the clock as soon as you ring us and say we're having a crisis. We don't work like that. If you've got a problem, always pick up the phone and just sort of say, look, this has happened. This is what we think we need to do. Are we right? Or do we need you to help? And we'll always be honest with you about that. And we can help you as much or as little as you need. We're not there to try and make money out of these disastrous situations, as Ruth knows from recent events. So at the end of the day, you are always far, far safer just making that call and just saying, this is what's happened. This is what we think we need to do. Are we right? Or actually, do you think that we need some help? And we are the type of people that if we think you can handle it yourself, we will try and get you to do that. We will support you, obviously, and we will help you in any way that we can. But we're also very aware of your budgetary issues and the cost of things. And so for me, the chance of just having that one phone call to just ring up and check, that is the vital key for me, is that you just pick up that phone and see if you're doing the right thing from the start. Is that okay,
Brilliant.
Ruth?
Thanks, Gemma. That's
Well,
great.
I think on my feet a bit then.
Glad that you were able to join us. Thank you for that.
Oh, don't get me started. That's my crisis management this morning, this IT service.
Perfect. Thanks, Gemma. Jack, I'm going to come to you next. So Jack works in our commercial litigation team, which is all things court related. I'm going to put it that way, Jack, that you guys are the big guns when we've got some real issues. And I think, Jack, you were going to just touch on a little bit around kind of debt recovery, where the school needs to recover some monies that are owed to it and how they might go about that. But I think it's fair to say, isn't it, in your team, again, we get some weird and wonderful queries. I remember one which was a parent who had decided to homeschool their child and decided to then send the trust the bill for their time in teaching their own child. And we were successful, Jack, weren't we, in defending that one. So, you know, there are some strange things that come to us, but Jack's going to just touch on a couple of minutes on debt recovery. Thanks, Jack.
No, good morning, everyone. Thanks, Ruth. I think that one was a little bit before my time, but it certainly sounds like something that we deal with. So, yeah, like Ruth says, I'm just going to touch on some debt recovery processes that you can have in place. Now, I appreciate we're not always the ones you want to see because it means something has gone wrong or could potentially be going wrong. But we do have things that we sort of, you know, try and tell clients and schools to help manage the process from as early as possible, and have those processes in place. So I think it's important to consider the legal and commercial factors, but there are also some reputational factors, obviously, for schools to manage, which I'll just touch on at the end. But I'll just give you a whistle-stop tour of the court process, as Ruth put it. But if you have any questions about anything that I do touch on or want a little bit more detail, please do just drop a message in the Q&A. So I think, first of all, before initiating debt recovery proceedings, it's, as I say, important to manage it from the outset. And I think in my very brief experience as a junior trainee solicitor, the important thing from the outset for the school is to maintain full and accurate records as best as they can. So that includes things such as, well, first of all, the agreement that the parent has signed when their child or children have started studying, and full statements of accounts, which is just to demonstrate the amount that's due as against the amount that we've received in, and we can track the amount that's been paid you know, from the outset, and we can see where the debt begins to accrue. Obviously, once the debt begins to accrue, that's when you'll sort of start to follow your internal debt process. And it's important to keep a record of any payment plans or any agreements that you may have with parents, as these will come handy if later down the line things take a turn and go the direction we don't want them to, but they'll come back and help us, and I'll touch on that shortly. It is also important to have an open and honest dialogue with the parents. There may be some reasons why they've got into some arrears. It may be manageable via a payment plan, as I say, or they may just need a bit of time, or they may be honest with you and come to you. Now, not everyone is like that, and we do have people that just bury their heads in the sand, and that's where we take the next steps. But as I say, this is just sort of stuff to help manage it and try and avoid you incurring unnecessary legal costs and coming to us when it's not necessarily required at that stage. I would say, after trying to, you know, send a letter reminding them that they've missed a payment, invite them in for a meeting and just take a note of that meeting and send a follow-up letter. Again, just keeping this documentation to assist if required further down the line. And just make sure that you follow your own internal debt process for each instance or case that you may have, to show that you are, you know, consistent and deal with things appropriately, and not just on an ad hoc basis, and you know, you're not following a set process. If all of that has not worked, and you do have to come and speak to me and my colleagues, unfortunately, then obviously we're more than happy to help and think about the different things that we can help you with at the start. Now, the first thing to think about for yourselves is the commerciality of that. In terms of the legal costs that you'll incur as against the recoverability. So it may be, as it is with some debts, that they're just not going to be recoverable due to that parent's financial or asset position, and there's just no point in you throwing good money after bad, or obtaining a judgment that isn't really worth the paper it's written on further down the line. So that's something that we can look at the start. It's also important, as I say, when we're managing these accounts, just to bear in mind that the limitation period for debt claims is 6 years from the date that payment fell due. There are sort of circumstances around that. For example, if they've made part payments of an invoice, it can restart that clock, but that's just the general rule. And finally, just on the commerciality point, if the value of the claim is under £10,000, then it will fall within what's called the small claims track at the county court. And it's important to note that legal costs are not recoverable in the small claims track, and it is very often that the cost that you incur will just completely outweigh and be disproportionate to the amount that's owed. So that's obviously something for you to consider as well throughout this process. Now, in the first instance, we have a debt recovery team who deal with undisputed debts and would take this matter on initially. I have spent some time in the debt recovery team and have come across quite a few circumstances of parents not paying their bills, shall we say. So the first step for them would be to send out a letter before claim or letter before action, which just sets out to the parent from ourselves as solicitors the basis of the claim legally, the amount that's claimed with any interest, and it gives them 30 days to make payments or make payment proposals, failing which we can begin court action. The 30 days is a requirement as per the civil procedure rules, which I won't bore you with the details of, but that's just something that we have to give parents or individuals prior to recovering that debt, which is also helpful because sometimes a letter from the solicitor, can just do the trick. It sometimes wakes people up and stops them burying their heads in the sand and makes them aware that you are dealing with this appropriately. So hopefully at that stage, again, we can come to some sort of agreement or a payment plan, and that can be it, and we can see the back of the matter. If not, then you can proceed to issue proceedings at the court. So that would be a claim which just, again, set out the basis of the claim, the debt that's owed, any interest, etc. And just briefly on the sort of the process after that. So a parent will have 14 days to file an acknowledgement of service, which basically just says, yes, I've received this claim, I'm going to respond. And then a further 14 days to either defend the claim, which is where those documents that we discussed earlier come in handy, admit the claim, or do what's known as a part admission, where they might admit some of the funds owing, but not all. And obviously we can deal with each of those, you know, with the relevant process for each, because they each have different ramifications. So, for example,
can I just interrupt you? Sorry, I know we're coming up quite close to the end of the session.
Yeah.
So just in terms of wrapping that up, then the key things for our clients are, if they've got any queries about the debt, anything where they're getting a claim or they think they need to issue a claim, and to be fair, it can not just be parents, can't it? It can be suppliers. It could be anything where the schools are owed money.
Yeah, absolutely.
And really what we're looking for is them to contact for support if that's what they need.
Yeah, brilliant. I would just say, just as everyone else said, just get in touch as early as possible. It's just the best and easiest way to help manage the situation and the risks involved.
Brilliant. Thanks, Jack. So everyone, that is a bit of a tour around different areas of crisis management. There is one more that I just want to mention. Unfortunately, my colleague Ridwan Omar couldn't be here today, but Ridwan deals with very sad situations, tends to be things like health and safety, serious accidents and fatal cases in some cases. And what I would say to you about that is, obviously, at the time of a crisis of that nature, which, you know, hopefully are very few and far between, but I do know some of you on the call have experienced some of those things. The best thing to do is obviously do the immediate things that you need to do and then give one of us a call. You know, the earlier, and I think the message from everybody is, the earlier you speak to us, and as Gemma said, you know, if you want to just speak to us, tell us what's happened. We can then talk about how we might be able to help and support. And from all of our education team this morning, you've heard lots of information. We've had lots of questions. So thank you very much for your questions. If anybody does have a question they want to ask offline, please do feel free to pop it through or whiz it on the Q&A very quickly now. But what I would say is, look, the key message this morning is give us a call. Look at what you need to do. In a crisis, don't panic. One of us will be able to direct you to the people who need to help you. And we don't just offer the legal support. We would like to think that we can also offer some emotional support and that general support to help you get through whatever the crisis is that you're dealing with. So thank you so much to all my colleagues this morning. As you see, there's quite a breadth of knowledge. I'm sorry that Ridwan couldn't be here, and we'll invite him on another occasion. But if you do have anything that's going to involve, unfortunately, things like coroner's inquests, health and safety reporting, those sorts of things, hopefully they're few and far between. But if you do need that support, do reach out. As ever, we will be back, I believe, on the 4th of December for our next Q&A. In between, look out for our events. They'll be coming through to you on your emails. Thank you all for attending, and a big thank you to all my colleagues this morning. We'll see you soon. Take care. Bye-bye.